Good morning, everybody. It is about 1 minute to 9. We're going to get started here pretty fast. We're going to be talking about title commitments today. I hope everyone is having a good Wednesday morning. Hopefully you can see my screen. I'm going to zoom in so you can see it better if you're on a mobile device or an tablet. See a few familiar faces. It's nice. Good morning, Jack.
Good morning, Sam.
All right, it's 9 o'clock. Let's get started. So today we are talking about title commitments. Go ahead and introduce myself for those of you that are new to my Zoom webinars. My name is Sam Saad. I am a real estate attorney based out of Naples, Florida, but I practice throughout the state of Florida. And we do real estate transactions, real estate closings in my office. I will put my contact information, my cell phone number in the chat. And if you have any questions, you can text or call, or you can email me, which also my email is in the chat. Normally I do a PowerPoint, but this presentation is going to be a little bit shorter because we're talking just about title commitments today. So I'm going to show you actual title commitment, and on your screen you see page 1 of an actual title commitment produced by my office. And we're going to zoom in. We're going to go through these in detail, talk about why it's important to get a proper title commitment, what title insurance does for your buyer, and basically go through this document. So let me zoom right in so everybody can see it. And right off the top, it is an American Land Title Association and ALTA commitment for title insurance. And what this document does, it has several parts, but it is a commitment or an offer for a title insurance underwriter, in this case, Old Republic National Title Insurance Company, who's my underwriter, to this is a commitment to insure the title to real property based on a number of conditions that we're going to go over. So right off the bat, again, you've got your notices. Of course, this is a legal document, so they want to make sure in all caps that this commitment is an offer to issue a title insurance policy based on the conditions and the requirements listed in this document. They want to make sure you know right away that it's not an abstract of title. It doesn't talk about the status of title. It just says if you complete the requirements, and the requirements are listed on a Schedule B1, which we're going to look at 2 of those, then you will get a title insurance policy that covers the marketability of your title. And a few things to think about in your sales contracts, whether you write a NABOR contract or a FAR-BAR contract or a FAR contract or any of the other contracts around the state of Florida, you're bargaining for marketable title. Marketable title is a title that can be resold by your buyer. So the purpose of the title insurance policy is to make sure that if anything does come up on title that would cause the title to be unmarketable, the buyer is covered with a policy of insurance that will make them whole. They'll either get their money back, or the title underwriter will defend the title and make it marketable in the name of the insured, which is your buyer. And again, it's a commitment to issue a policy according to the terms and provisions of this title commitment. The title commitment is effective as of the date of the title commitment, shown on Schedule A, which we're going to look at, and it's good for 180 days. So for those of you with a longer closing, think about that. We need to be careful when we pull title. That's pretty far out, though, for most, I would say 99% of the typical real estate closings we do. And of course, the policy is signed by the president of the Old Republic National Title Insurance Company and the secretary. This is Old Republic, Florida. So this is signed out of Tampa. And these are digital signatures, of course. And I want to point this out here. This is a 2021 Alta commitment for title insurance. Every few years, the American Land Title Association updates its title documents, its policies, its jackets, we call them, and its requirements. And this is the 2021 version. It's the most recent version. So in this title commitment, which again is really a contract by the title company to issue a title policy if all the requirements of the policy are met. We have contractual definitions, and they're what you would think they'd be. The only one that's very interesting is the discriminatory covenant. Anything that discriminates against a class of individuals is no longer valid under the U.S. Constitution. But some of those things go back before the Civil War. They may be in your title, and they would just be considered not actionable items and are unenforceable. Then, of course, we have a definition of land, which is going to be our real estate that we're talking about, and that's defined in Schedule A, and a few other definitions for mortgage, policy, amount of insurance, the proposed insured. This is your buyer. This is your buyer. They'll be defined on Schedule A as well, which we're going to get to in a minute. A few other definitions. And then one important point about the terms of the title commitment. The title commitment may be amended at any time. And it's an interesting point because NABOR just changed its contract for 2025 to allow updates to title. So if something does come up and the title commitment is updated, the buyer may now make a second title objection under the NABOR contract. So that's an interesting point. It's always been in the title commitment that the title underwriter can update this, but it's only recently added to the contract, the NABOR contract, that you could actually have an actionable issue if title is updated. So scrolling through, again, the company limits its liability. And one of the most important liability limitations is if your buyer knows about a title defect and does not disclose it, then they don't get insurance. You can't insure the burning house, as the insurance companies like to say. So if your buyer knows of a problem in the title and didn't tell me about it, then they're not going to get title insurance. And that's going to be a big deal if it becomes a title defect that they have to defend on their own later, because title defects are very, very expensive to defend, which is why title insurance is such a good deal. Because again, it's a one-time payment at the closing, and it covers you for your life of you and your heirs. So buyers get a lot of coverage under title insurance unless they didn't tell the title insurance company, about a problem. Okay. Few other conditions and parts of the contract, not super relevant for realtors, mostly just deal with like in a commercial context, you could get a pro forma policy. We don't really do that in residential. It gives you procedures for claims if there was going to be a claim. And then, of course, the title insurance company limits itself to arbitration if there's a dispute under the commitment. Okay, so let's get into the three schedules of a title insurance policy. And I'm going to zoom out again so you can see it in full, then we'll zoom back in and talk about it. This is Schedule A. There's a Schedule B1 and a Schedule B2. So let's talk about Schedule A, then we'll go to B1, then we'll go to B2. Schedule A is your transaction identification data. And it talks about, I'm your title insurance company. I own Paradise Coast Title and Escrow, of course. And that is the agency of Old Republic that I own. You've got the address of the property that's going to be insured. This, of course, is a fake address, 123 Happy Street in Naples. And then you've got my file number, you got the commitment number, and some other data in here. But again, this all goes to Schedule A of the policy. Schedule A is, again, the data. You got your commitment date. So this is the date when the title insurance starts. The underwriter agrees to insure the title from the commitment date, provided all of the requirements of Schedule B1 are met. And then in this case, there's going to be two title insurance policies issued, an owner's policy and a loan policy. And I'm going to talk for a minute about the difference between an owner's policy and a loan policy. The most important difference is the amount of the insurance. Notice here, the owner is being insured for $785,000. Our buyer, Bob and Barbie Buyer, are getting a policy of insurance for $785,000. The mortgage firm, which is our lender in this case, is getting a policy for $706,500. That's the loan amount. So what happens if Bob and Barbie Buyer decide that they don't want title insurance, even though their lender is demanding title insurance to cover the loan? You've got about an $80,000 to $79,000 difference here. That's Bob and Barbie's equity that would not be covered by the title insurance policy if there was a title defect later on, whereas the lender, the mortgage firm, would be covered for their $706,500 mortgage. So Bob and Barbie really are standing to lose $80,000 if they don't get title insurance on this particular piece of property. That's what we issue two policies. We issue them as simultaneous issue. So the owner, Bob and Barbie, are not going to pay for two policies per se. They're going to pay for their policy, and then they're going to pay a simultaneous issue fee, which is much smaller depending on the situation, usually between $25 and $250 for a policy for the lender. And that information, of course, is set out here. And then, of course, the type of title, fee simple, you all remember from your real estate classes, fee simple title is what you typically are looking for. That's the bundle of sticks that the buyer is getting. And it says it again right here, the estate or interest of the land at the commitment date is fee simple. That's the seller has fee simple title. They don't have, for example, a life estate or some other title, leasehold title, some title less than fee simple. They own all the bundle of sticks. And at the time the title commitment is issued, the commitment date, we have our Samantha and Saul seller. They received a deed that was recorded in last year. And this is going to be the person that needs to deed out. So a lot of times if you've seen my other contract seminars, you've heard me talk about who's your seller. Well, this is your seller, whether an LLC or a trust. In this case, we have a single woman and a married man. So that's going to create some interesting title questions as to who has to sign what, whether this married man has to sign because of homestead or whether his wife has to sign because of homestead. So we'll talk about that as we get through the title commitment. And then, of course, the land as described as follows, and there's an Exhibit A to this title commitment. Exhibit A is your legal description, and we'll look at that. That's the land to be insured is your legal description. And then I sign Schedule A as your title agent. Okay. Before I move on to Schedule B1, because it's going to get pretty detailed in Schedule B1 and B2, does anybody have any question about Schedule A? Everybody understand it's your basic information? Okay. So let's dig into the meat of the title commitment, which is Schedule B, Part 1, the requirements. The requirements are stated simply are what I have to do as the title agent to get this title marketable so that the buyer can buy marketable title, which is, of course, what they bargained for under the contract. So there are a lot of this is standardized. We're going to actually look at two Schedule B1s today because there are a lot of options in B1, but just basic stuff right off the bat. The proposed insurer, that's your buyer, has to notify the company of anybody who is going to obtain an interest in the land who is not referred to in the commitment. So going back to Schedule A real fast, whoever is listed up here in as the proposed insured, they need to be listed. They're the person that needs to be on title. Mary, you have a question.
Thank you, Sam. I have a question. We had a situation where the legal description, because you addressed the Exhibit A, the legal description,
Right?
that the title insurance company changed the legal description to remove access to the lake. Luckily, the attorney, because the buyer had an attorney, caught it. They were able to go back and fix it and obligate them to fix it because they were able to prove that the title insurance company should not be not the title insurance. Yeah, the title insurance company should not have removed that. Why would they do that? And should we be more careful in looking out for that? But
So I'm not sure why a title company would remove an access to a lake. Maybe there was an easement issue that they didn't want to deal with. That would be a very unfortunate situation. The way it's supposed to work in most cases is the title agency, Paradise Coast Title, for example, we call up Old Republic and we say, please provide us a title commitment for this property. And we give them the legal description that we find in the public record off of the last recorded deed. We give them the seller's name, we give them the buyer's name, we give them the address, the purchase price, the loan amount. And then they produce a title commitment and they research the legal description and make sure that it's accurate and correct based on the contract.
mm-hmm.
So
So
there may have been an issue in the contract or something, but that's very
they just
strange that they would
removed it.
remove it.
Yeah, they just removed it. So apparently the reason that they gave us was that they did not want to cover the access to the lake. However, in the middle of the transaction, the seller was getting permitted to build a dock. So there was
Mm.
access to the lake. This was in the area of Windermere, and it was a historical area. So I guess several years ago, about 15 years ago, there was some type of a lawsuit where the everyone that had access to the lake had to agree, where the judge came back that all the homeowners that had access to the lake, there was an easement, and that they would have to allow that easement to remain. But the access to the lake, and it was that way in the documents from the judge, that the legal description will stay the same and that the access to the lake will still remain. So
So
the
that means
attorney
that
was able to prove
they
that
probably were
argument.
just dealing with it as quickly as possible, like some title companies do. But
Hmm.
we
But it's
will
just
we'll
weird.
talk
Why
more
would they
about the
do
legal
that?
descriptions.
Yeah.
Okay, so let's keep going. Um, so then you the again B1 we talk about notifying the title company. Then we talk about the buyer's got to pay the agreed amount for the estate or interest to be insured. The buyer's got to pay the premium and charges for the title insurance policy. And then we get into really the stuff that we care about the most, which is the deed and the mortgage need to be recorded. That's how we transfer the title. The warranty deed, of course, you all know, is the document that transfers title from the seller to the buyer. Um, the mortgage is the lien from the lender. And you'll notice here, remember I said we had Bob buyer and Barbie buyer? And then we have this crazy language that you'll see in title commitments, joined by spouse if married or non-homestead language, the proposed mortgagees. Well, and we're going to talk about this on the other title commitment as well. Homestead in Florida makes a mess of things sometimes. And if Bob the buyer and Barbie buyer are not married, then we may need a spouse if one of them is married but not to the other to join in the mortgage. So you will see mortgages that say things like joined by so-and-so for purposes of spousal joinder. You'll see title agents write things into the mortgage like that. That's what that means. The lender wants to make sure that the homestead rights are secured for anybody who could come and claim against the property. And the title company, which is what we're talking about today, wants to make sure that they don't have a title claim from a spouse who never signed the mortgage. So we put a requirement in our title commitment that spouses have to join signing in the mortgage if one of the borrowers is married. And we'll talk about that in the context of the deed, which has the same requirements for unmarried sellers. For sellers who are married, but the spouse is not on title, when we get to the other title commitment. Then, of course, the taxes have to be paid. This is always a requirement that the current year's taxes are paid. You notice this says proof of payment of the 2024 taxes because 2025 taxes are not due yet. And when we get to B2, the Schedule B2, you'll see there's going to be a lien for the 2025 taxes. So we notice here on this particular title commitment, no open mortgages were found of record. What does that mean? That means our seller owned the property free and clear, but it says here, agent should confirm with the owner that the property is free and clear. How do we do that? We ask our seller to sign what we call a no mortgage affidavit, stating that there is no mortgage on the property, that they didn't borrow money and fail to record. Next up, in this particular case, the homeowner association that covers the property is going to be required to provide an estoppel letter. I could do a whole separate class on estoppels. Of course, they are a frustrating document that we must get from homeowner and condominium associations, showing the current status of the dues to the association from our seller. This document typically is ordered immediately upon receipt of our title order and takes 3 to 10 days, depending if we have to rush it or not, to get the estoppel. Of course, many associations take much longer to get the estoppel, and that raises a whole set of issues under Florida statutes for when a seller actually has to pay for an estoppel. Again, for another class, but for our purposes of our title, we need an estoppel letter. And then the seller is going to execute some affidavits by the typically do one affidavit, a closing affidavit, and it's going to establish several things. It's going to establish that the party is representing possession and no adverse matters. That's the seller doesn't have anybody like a tenant in there or somebody else claiming against the property. Anything that would give rise to litigation or a lien. So a lis pendens that could pop up. Typically, you're talking about like a not an eviction necessarily, but a unlawful detainer. And then, of course, closing funds have to be dispersed by the title agent. We have to make sure that everybody is paid, that the estoppel is paid for, the association is current, any mortgage is paid off. No mortgage on this title commitment, but there are typically a mortgage to pay off. The funds have to be dispersed. And then again, with that same affidavit that we said, the closing affidavit, again, there's no one other than the actual owner in possession. That's like again, evictions. Now, surveys come up and are very contentious because buyers don't like to pay for surveys. If you don't have a survey, then there will be an exception in the title insurance policy for anything that the survey would have discovered. So it's very important to get a survey. I'll also say this about surveys. Surveys are the second most important document in your closing process. The first, of course, is the deed, which transfers the title. But who knows where Lot 11, Block F of the Lake Park subdivision is? Anyone? Anyone? No, of course not. But everybody knows. If you look up online, you'll see where my address is, and you'll know where I live. But how do you tie the legal description in the deed? Because there's no address in the deed. So how do you tie the legal description in the deed to the piece of land that you own? Well, the document that does that is the survey. It lays out where the property is on the earth in relation to the other properties around it and tells you where it is. So I really always encourage buyers to get a survey. It'll show if fences are on your property or not on your property. It will show if your neighbor's air conditioner is on your property. All types of things that the survey provides. In Mary's example of the lake easement, that probably popped up on the survey and the title company didn't know what to do with it. So you always want to get a survey. I can't emphasize that enough. And then the next one on this title commitment, remember we're on B1, schedule B1, which is our requirements, is an update of the search that must be completed just prior to closing. So again, we do a title search. When you give us the title order, we do it right away. We get it back in 3 to 5 business days. And then we go through the closing process. Then just before closing, we do another title search to make sure that nothing pops up on title in the interim. What could pop up on title? A seller could pass away. One person on title could die. Both could. I've had one several times actually. A notice of commencement could be filed against the property. In the case of a condominium, maybe the association is commencing post-hurricane work, and that's going to affect title to the condominium. In a single family context, maybe the seller signed a contract to have some work done as a part of the repair process for the inspections, and then the contractor that coming in to do the repair signs a notice, has the notice of commencement signed and files it. That becomes a lien on title. So this gap search, we call it, this title search at the end is very, very important. Okay, I'm going to switch over now. You've seen Schedule B1, the basics of Schedule B1. Let's dig into some of the more interesting, I'll call them B1 issues. Can everybody see this title commitment? I see heads shaking yes. So we're going to skip all the regular stuff that we talked about before. Let's dig right into the hard stuff. Written consent of the board of directors of the association must be recorded. So on this title commitment, now we've got a homeowner association that must provide a consent. Those consents, as many of you know, typically take 20 to 30 days for the association to go through the approval process, do a background check on the buyer, and then approve them. And then the board of directors has to vote on it sometimes. Then the president has to sign the written consent, the certificate of approval. So written consent has to be received from the association. And that's the typical in most associations, a COA or a certificate of approval has to be received. Now, remember I said earlier in the case of the mortgage, where the mortgage required spousal joinder. Well, here we've got a couple of things going on. We need a warranty deed from our seller, Paul in this case, individually and as trustee of Paul's trust. And then notice again, it says joined by spouse if married or non-homestead language. So not only do we have to get a deed from Paul individually and as trustee as our seller, we may need to talk to Paul's spouse, because if Paul is married and this was Paul's homestead, even though the property is held in trust because of Florida homestead law and the Aronson cases, that's Arnson, Aronson cases, which say that you cannot disinherit a spouse even through a trust, Paul's wife is going to have rights to this property. And I hear a lot of frustration from realtors when I tell them, yeah, the property's held in trust, but we need the wife's signature. And then we find out that they're not speaking and she's estranged and they're getting divorced and they hate each other and all these things. And whoops. And so we have to go in and talk to the spouse. And this is actually something that I pride myself on being very good at, just explaining there are homestead rights that need to be extinguished. You have to sign the deed. The alternative is if the property is not homestead, we put the non-homestead standard language in the deed and spouse does not have to sign. Okay. In this case, in our example on this one, Paul and Karen had a mortgage from mortgage to mortgage electronic registration system as nominee for Countrywide Home Loans. Anybody here remember Countrywide? The massive bankruptcy. Bank of America bought them, and then they lost a couple million mortgages, and we all have to deal with this now. So hopefully MERS, that's the Mortgage Electronic Registration System, has Paul and Karen's mortgage in their system, and we can find that mortgage and get a payoff, because we need to record a satisfaction. Otherwise, Paul and Karen are going to have to sue their lender, who is, of course, bankrupt, and that's always a problem. Also here, another fun one you'll see on your title commitments, a sufficient funds affidavit. We have a condominium association for our property, and that condominium is having work done. So that means a notice of commencement was filed against the association. This is a condominium, which means all of our homeowners, all of our condo owners have a lien on their property, and the association president has to sign a sufficient funds affidavit stating that the association can cover the cost of the improvements, or that there will be assessments installed to cover the improvements, or that the improvements have been paid for in full. So those sufficient funds affidavits are very difficult to get out of the association in a lot of cases, because they don't know what the final amount of the $30 million roof replacement is going to be. They just know it's a lot of money, and they're going to have to assess their owners. So sufficient funds affidavit can be a delay in closing. And we have procedures and methods for getting those taken care of when the association is being difficult, including we may have to go through the bonding process and get the notice of commencement bonded off of our specific condominium based on a prorated amount of the estimated cost of repairs. And if you can say all that 2 times, you are amazing. So again, we need an estoppel from the association, and notice we needed a written consent of Falling Waters up here. We need an estoppel, and we need an estoppel down here, because we have a condominium in an HOA. So this is a very detailed, we'll call it, interesting title commitment with a lot of moving parts. I wanted to show you this title commitment because this one had a specific interesting one. This title commitment wants us to record sufficient proof that the terms and conditions of the declaration of condominium regarding transfer of appurtenances have been complied with. And you say, what's an appurtenance? Well, in this case, it was the exterior components of the HVAC system that had to be transferred as a limited common element under the declaration of condominium. So what we have to do as a title company, go back to the association, explain that they had requirements in their declaration, and get another affidavit from the association, which we did. So this is just some of the things you have to deal with. In this particular case, also, our seller is an LLC. So now we have to examine the LLC and the operating agreement and the articles of organization of the LLC to make sure that it's in good standing under the laws of Florida, or wherever it's formatted. In this case, it's Florida. Now, Florida makes it very easy to do this because you go to sunbiz.org, and for those of you that have taken my contracts classes, you know we look at sunbiz.org to verify LLCs when we're selling the property, and your title agency, Paradise Coast Title, we will do that again for you. But we look for a good standing on sunbiz.org and make sure that this property management LLC is a valid LLC. Then we have to confirm the authority of the individuals designated to bind the LLC, which means we look not just to the articles of organization, which are a public record, but we have to go to the seller and say, seller, we need to see the operating agreement of your LLC. Remember, LLCs, of course, have 2 major documents. That's the articles of organization and the operating agreement. The operating agreement supersedes the articles of organization, and it says who is in charge of the LLC. It has to be examined by the title agent. Again, for those of you that take my contracts classes, you've heard me talk about how as a realtor, you need to look at the operating agreement and make sure that the right person signed your contract. And you can always send it to me, and I'm happy to help you do that. And then again, this title agreement requires an affidavit saying that there's no litigation going on. Okay, so those are some of the crazy issues that you see in title commitments. Before I go to the Schedule B2 and talk about the exceptions, does anybody have any questions on the Schedule B1 requirements? Feel free to unmute yourself or raise your hand or put it in the chat. Any questions? Okay, let's move on to Schedule B2. So Schedule B2, oops, Susan, you're drawn on the screen. I don't know how she did that. Okay. So Schedule B2 has exceptions. The exceptions to title are things that don't come off the title no matter what, unless you have meet certain other requirements. But they're things like the covenants and restrictions of the association, anything that's on the plat of the of the PUD, in this case Indigo Lakes. Those are items that don't get erased. They are all, the seller takes subject to the plat, subject to the covenants, conditions, and restrictions. Other items that are on this title, subject to the environmental resource permit that was recorded by the developer. The telecommunications easement that gets the Comcast in there. So these are all things that you take subject to. And then this resolution by the Collier County Board of Commissioners. How many people here wonder where their garbage assessment comes from? It's by resolution of the county commissioners, and it's a lien on title. So if you don't pay your garbage bill, you run into a problem. Now, let's talk for a minute about a few other things on Schedule B2. All of this stuff right here, numbers 1 and 2, these are the general exceptions to title. And a good title agent will go in, they'll do a lien search, they'll check they'll get a survey, and they'll do all the other things required. You actually can delete these standard exceptions to clear the title and give your buyer even more protection. And we do this as a matter of course in my office. But if you look at a title policy, someone who's issued a title policy and the general exceptions were not deleted, then you have a question for your title company as to why they didn't provide the maximum coverage to the buyer, to your customer. Okay. Last thing here is Exhibit A. Exhibit A is the land that's being insured. In this case, it's Lot 4, Block A of Indigo Lakes, Unit 1. And this is the legal description. You'll notice here, according to the map or plat thereof, as recorded in the Plat Book 34, page 76, Public Records of Collier County, Florida. This tells you a lot of things. You've got your lot, your block, your development, what unit of the development, it's a plat, and where it's recorded and what county it's in. All necessary parts of the legal description. With that, you've now been all the way through a title commitment. I'm going to scroll back up to Schedule B1, and I'm open to any questions that people have. Let's see. Bob, you're asking, Bob, this is an example, so don't take this as gospel. I made most of the requirements up as a mixture. So yeah, I'm not sure if Falling Waters has an HOA on top of a condo or not, but don't take that as gospel. These are examples. Other questions? I see some really smart agents on here. You must have some questions. All right, if there are any, then that is title commitments in a nutshell. And I look forward to working with all of you. Paradise Coast Title and Escrow is, of course, open for business. Should you have any closing needs, you feel free to give me a call anytime. With that, thank you very much, and I will see you all on the next Zoom.
Thank you, Sam.
You're welcome.